Well, good afternoon, Michiganders. It is Tuesday, January 5th, 2021. Welcome to a new year. And of course, this is Tuesday with Tom, Michigan's only weekly internet show where we do answer your questions about estate planning and estate settlement in Michigan. And, of course, we don't send you a bill. I'm your host, Tom Doyle, estate planning attorney, lifelong Michigan resident, and ambassador for all things good in this great state of Michigan. Welcome to today's program. Just a brief recap. Last episode of 2020. Should I make a gift to my church's endowment fund? Perhaps you were looking at doing some year-end planning, or maybe in 2021 you're going to give some consideration to making gifts to your churches or your church school's endowment fund. If so, in the last episode, I suggested questions that you should ask and get answers to if you are going to consider making contributions to an endowment fund for your church or children's school. All right, we're off to the start of a new year. Many of you had made resolutions about getting your estate plans in place during 2021. You might be going through your records, looking at different documents that you're going to need in order to look at and provide to the attorney. And of course, you likely have real estate, and going through your real estate, you look and you say, hey, bought this real estate on a land contract. Well, today's episode, what happens if you don't get a deed when you pay off your land contract? But please remember that what I'm about to discuss during the program is for educational purposes only. It is not intended to be legal advice. You need to work with your attorney to determine what is appropriate for you and your estate plan. Again, what happens if you don't get a deed when you pay off your land contract? Amanda and I frequently find when we're sitting down with our clients and we're looking through their information regarding property, it's not uncommon to find a client here in the state of Michigan who has purchased property on a land contract. Perhaps that's you. Question: did you pay it off? Answer: yes. Question: where's the deed that you received from the seller when you paid off your land contract? Answer: I don't know that I ever received one. Well, let's step back a second. What is really happening when you buy land on a land contract? It is not the same. Unfortunately, people are oftentimes confused. It is not the same thing as getting a mortgage. When you buy land on a land contract, you do not get a deed until you make your final payment. That, in fact, is when you now own the land. Until you make that final payment as required under the land contract, you only have what the law refers to as an equitable ownership, meaning you'll have the right to have ownership entirely once you pay off the land contract. So what does that mean? That means legally the seller, the person who sold you the property in the land contract, still legally owns it until you make your final payment. So what should happen when you make that final payment? You, at that point, should be given a deed to the property signed by the seller that reflects that you now own that property. One piece of advice: you're getting ready to make your final payment. Don't make the final payment until you're sure that the seller is ready to provide you the deed. So if you're getting ready to make your final payment, make sure you're in contact with the seller and say, hey, do you have a deed prepared? Let me review the deed. Let me have my lawyer review the deed to make sure it's going to be right, so that when I make this final payment to me, you in turn are going to be providing me with the deed, because again, you don't own it until then. But once you make that final payment, you have the right, and the seller has the obligation to provide you with that deed. Well, you're sitting in our office. You've already paid off the land contract, but maybe you're not sure you ever received a deed to the property. What do? Well, start by this. Let's start here. Make sure you've got your land contract, and make sure that you have all of the payment records reflecting all of the payments that you've made on the land contract. So what we'll oftentimes start with is check with the Register of Deeds. Hey, check with the Register of Deeds to find out if a deed was ever recorded. If not, now it's going to depend. One, if the seller is still alive. If the seller is still alive, that's kind of the easy one. What you're going to do is you're going to contact the seller and say, hey, I paid off the land contract. I never got a deed. You have to provide me with the deed. And if the seller is honorable, they'll provide you with the deed. They might say, hey, forgot all about doing that, but yes, I will provide you a deed reflecting that you've paid off your land contract. But what if the seller says no? What if the seller refuses, or you can't find the seller? Well, now you might have to file a lawsuit. You might have to file a lawsuit against a seller to get a court to order the seller to provide you a deed to the property. Or you might have to file a lawsuit to what we call quiet title, which is, I know I paid off the land contract, the seller is still out there, I can't find him, and I'm asking the court to essentially legally issue an order that recognizes that I am now the owner of the property. Again, though, in any of those situations, whether you're looking at having to file a lawsuit against a seller or you're looking to quiet title, you need evidence that you paid off the land contract, which is why I go back to what I mentioned a few moments ago. Organize your records of payments, because you're going to need to have accurate records to prove that you in fact paid off the land contract. What happens, though, if the seller's died? Well, now what are you going to do? Well, think about this. The seller still owned the property when they died. That means the property is now part of the seller's estate. And we now need to find out who's in charge of that estate. So first question, has a probate estate ever been opened? If a probate estate has, in fact, and is still open for the seller, then the first step is going to be contact the personal representative. That's the person who's in charge of the estate. Provide evidence to the personal representative reflecting that you had a land contract, reflecting that the land contract was paid off, and asking the personal representative to now provide you with a deed to the property. If the personal representative says no, if they refuse to provide you with the deed, well, then you're still going to be filing a lawsuit, but now you'll be handling that through the probate court, because it's the probate court that will be overseeing the probating of this estate, and it will be the probate judge that will have the authority to order the personal representative to provide you with a deed to your property. But what if a probate estate hasn't been opened? The seller has died, a probate estate isn't opened. Well, you now are going to have to go forward and have that probate estate open, because there is no way to convey the property to you from a seller who's died unless a probate estate is open. Again, you're going to need a copy of the land contract. You're going to need proof that you made all of the payments under the land contract. And then under the probate code, under Michigan's law, you would be considered an interested person, i.e., a person who has the legal right to petition the court to open a probate estate if a probate estate has not been opened within 28 days after the seller's death. So if 28 days have gone by, you have the right to file a petition with the probate court. And the problem with that, although it's the only option that you have, you're likely going to be hiring a lawyer, because my guess is you're not going to know how to go about handling that petition. You're likely going to be requiring a court hearing, appearing before a judge, presenting the evidence before the judge that you had the land contract and that you had the payments all made, and it's going to cost you money. Amanda and I, we probate a lot of estates. Minimum, we're likely looking at maybe $4,000 to $5,000 in attorney fees, which means what? It's a whole lot less expensive for you to make sure that you get that deed up front when you pay off the land contract than to have to open a probate estate up after the seller has died. Now, if you're not sure, maybe you've lost contact with the seller and you're not sure if the seller is alive or not. Now, what likely you will be doing is you're going to use one of the searching services that look for heirs, and you're going to pay money. They're not inexpensive to use, but there are services out there that will conduct a search and will locate heirs and will determine whether or not a probate estate has been opened. And if not, at least you'll have the information on who the heirs are, because in opening a probate estate up, you do have to notify the last known heirs that you are probating that estate. So bottom line is what? Bottom line is this: it is much less expensive to be sure you get the deed when you make the final payment than it is to wait and have to open up a probate estate. So if you've got a land contract out there, if you're sitting there looking at your estate plan and you have a land contract, if you're already making payments and you know where the seller is, make sure you track where that seller is. Make sure that you do get a deed at the point in time you provide that final payment. If you've paid off the land contract and you know where the seller is, contact the seller as soon as possible to make sure you're getting that deed so that they don't die in the meantime. And now you'd have to be dealing with a probate situation. And finally, if you've paid off the land contract and you don't know if the seller's dead or not, or the seller has died, but you don't have any information about that, or you need to now open an estate up because a probate estate has never been opened, those are all the times that you're going to be looking to have to at least consult with an estate settlement attorney, such as we provide that service in our office, to look at what are the options that you have and what's the process that you're going to follow in order to get the deed to the property. Because until you have it, let's assume you've created a trust. A lot of clients create trust, and this comes about because now they want to put their real estate inside the trust. The problem is, until you have a deed, until you own it, you can't put it inside the trust. So if you're looking at saying, hey, I'm creating a trust, maybe I'm creating the trust to avoid probate, and I want to put my real estate inside this trust, now there's going to be additional work to do because you have to have that deed in order to put that property inside your trust if you in fact have paid it off. Before I continue on, a brief reminder, though, as always, that Amanda and I would be honored to have the opportunity to help you. If you've got a problem with a land contract and you can't locate the deed, it is something that we can help you out with. Or perhaps you've got the need to put together an estate plan or amend an estate plan, or you need some assistance in settling an estate yourself, even if it has nothing to do with a land contract. Well, there are a few ways that we can be of assistance to you. And a lot of what we are doing today is being done virtually. Because of COVID-19, because of the not wanting to expose you to risks to your health, much of what we are doing today is all being done virtually, i.e. through our website, which is doylelawpc.com, and consultations, which will be either by telephone or Zoom consultations. So what do we make available to you? Well, if you're a prospective client, if you're somebody that we haven't worked with before, and you're thinking about getting your estate plan done, or you've got a question about settling estate, I invite you, go to doylelawpc.com, click on the virtual office tab. That's where basically most of this happens. You're going to have some options under there. One is a planning from home option. That option is there to assist you in obtaining a complete estate plan from the safety and comfort from your home. You can download a copy of our estate planning guidebook. You can schedule a consultation, whether it's going to be Zoom or by telephone, and we can be of assistance to you that way. If you're a current client and you're looking at perhaps needing to update your plan, well, under the virtual office tab, you're going to find an Update My Plan option. Tell us what it is that you're looking at changing. We'll get back with you and let you know what the cost is going to be and how to proceed. Again, if you're a current client, but you want to schedule a consultation, maybe you want to talk about whether you should update your plan or not, or you have some other estate planning or estate settlement questions, just utilize the schedule consultation feature. That, again, is available under the virtual office tab. And again, we also now have our legal store. Our legal store is an option that's available at doylelawpc.com. Through the legal store, whether you're a new client or current client, if you just need an individual document, maybe all you need is an appointment of funeral representative because your plan was done before appointment of funeral representatives were done. Or maybe all you need is a power of attorney, etc. Well, go to the legal store, again at doylelawpc.com, and you can order individual documents to be prepared for you as well. Well, I think that's going to be it for today's show. As always, though, if you have a comment about the program, a topic that you'd like to have me discuss, or questions that you'd like to have answered, please send me an email, tom@tuesdaywithtom.com, or mail me a postcard, Tom Doyle, P.O. Box 16066, Lansing, Michigan 48901. And as always, to stay current on what's going on with the law, what's going on with the office, and other information, please follow us on Facebook and Twitter. That would be doylelawpc.com. That's the office. Follow Tuesday with Tom. That again, Tuesday with Tom at Facebook and both Twitter. And one of the things that you can find if you haven't followed the Tuesday with Tom Facebook page or the Twitter, not only do we have information about previous podcasts that we provided and the ability to listen to new podcasts, also try and provide information, interesting information, about what's going on in the state of Michigan in case you're looking at doing some traveling or other things throughout the state of Michigan. Remember, too, though, that the Tuesday with Tom app is available in the App Store. The program is also available on a number of channels such as Apple Podcast, Google Podcast, Spotify, iHeartRadio, Spreaker, and as always, you can ask your smart speaker to play Tuesday with Tom. I apologize. I guess my voice is going out a little bit on me today, but I want to thank you again for spending your time with us today. And as always, I hope that you have an awesome day and an awesome week in Michigan. Stay safe. Tuesday with Tom has been brought to you by the estate planning attorneys at Doyle Law PC. To learn how we can help you with your estate plan or with settling a loved one's estate, please call us today at 517-323-7366. That's 517-323-7366.